Hi, everyone. Welcome to the third in the series of Northeastern game design guest lectures, guest speaker talks. This is hosted out of the Northeastern game design program. We have a Master of Science in game design, and we also have a, Bachelor of Fine Arts in game design. And you can learn more about those at camd.northeastern.edu /programs /game science and design MS or /game design BFA. Today we have Leah Norod visiting us from William Morris Endeavors. Leah is a business affairs executive, and William Morris Endeavors is one of the world's leading talent agencies, where she helps to support the agency's digital and non-scripted departments. She is passionate about helping creatives understand their rights and navigate the legal complexities of the industry. And before joining WME, she was in-house counsel at Whistle Sports, where she handled production legal matters for digital content. We also spoke a little bit about getting here today, and something that Lee and I both thought was important was to allow some time later on in this presentation for questions. So when I pass it over to Leah, maybe this is something, I guess, depending on what your preferences is, if you want people to put questions throughout, like in the comments, and you'll answer them, or if you want them to save it towards the end. And thank you for being here.
Yeah, no, I'm super happy to be here. I think I don't have a strong preference on the questions, like in terms of timing. I know we've saved time at the end for those, but if there's something that's burning and you don't, want to forget it, you can either throw it in the chat, and James can monitor that and flag it to me, or alternatively, you can just raise your hand or interrupt me, whatever. It doesn't matter. But we do have time, I think, at the end reserved for a Q&A. I'm just gonna take a quick sip of water. It's allergy season. Okay. So yeah, so let's get into it. Welcome to, I'm sorry again for the title. Ready Player Fundamentals of Entertainment Law. I thought it was kind of funny. One of my big pet peeves though is like lawyers that try to be a little too clever with their puns. So apologies for inadvertently doing that. But in speaking with James, you know, he had mentioned that it might be a little bit helpful before we get into like the meat of it, for me to give a little bit of information about my background. So as he said, I am a business affairs executive at William Morris Endeavor. We are one of the top talent agencies in Hollywood in the entertainment industry. And we represent like a wide spectrum of individuals, like from traditional like Hollywood talent to digital creators. And my role specifically is I support the digital group, which primarily is like YouTubers, like social media influencers, podcasters, like basically anything in the digital ecosystem, games, and game influencers as well to bring it a little bit more specific to this talk. And then also non-scripted content, so documentary films, reality TV, competition shows, stuff like that. Those are all in my coverage area. And my background is it's funny because I get asked this a lot by law students, which by the way, I don't know if anyone here is either interested in law school or perhaps like an aspiring attorney. Like there's all types of backgrounds. Like you don't really have to have a specific degree before you go to law school. So if there's anybody interested, feel free to let me know when it's time to, I guess, have a Q&A or whatever. Just so I know kind of if there's anything specific I can help give you advice on. But anyways, when I went to law school, like I went with the hope of practicing entertainment. Of course, it can be a bit of a difficult field to break into. But I had in college, and I'm laughing because I just think back on it, and I'm like, I just felt like I was kind of stumbling through all this. But when I was in college, I did an internship at a courthouse in my hometown, and I thought I wanted to be a lawyer because I was studying English literature and history, and I had this certain skill set. And I was like, I think I'd be good at this, but I don't know if I want to be doing what these lawyers in this courthouse are doing. Like, this doesn't really resonate with me. Like, I kind of wish there was a way to meld my personal interests with the work that I'd be doing. And so I quite literally Googled, like, is entertainment law real or like, is this a thing? And I was delighted to find out it is. So from there, I was like, okay, well, I'll just go to law school in New York, and try to pursue this. And I tell people that it was like a little bit of luck and hard work. Like it was like a combination of those two things. That I was able to get an internship in my law school career at a entertainment firm, was able to kind of get in there and build those relationships. And then I ended up going back as an associate attorney, and I was there for 4 years. And from there, I moved to Whistle Sports and then ultimately to WME. So it's been a journey. It's a really fascinating field, as we'll get into it a little bit. And it covers like a wide spectrum of things, which I think back when I Googled it in college, I didn't quite realize. So I'm going to attempt to go to the next slide. So what is entertainment law? It takes it's a wide topic. It's a wide practice area. It can include music, it can include production, it can include, just like litigation, employment. Like there's all these different facets that, you could be considered an entertainment lawyer if you're working within the industry. For myself, what it means when I say it is that I am primarily a transactional attorney. So I generally handle contract negotiation, not so much anymore in my current role as a business affairs executive, but in previous roles, contract drafting, um, and really kind of walking people through their rights and understanding different contractual provisions alongside intellectual property, which is just the basic foundation, in my opinion, for entertainment laws to understand, IP rights. And so in my day to day, what I generally do is I will be helping agents to negotiate deals on behalf of their clients, typically, like I said, in the digital and the non-scripted space. And we'll go through the different deal points. And it might be, like a hosting gig. It might be a podcast distribution deal. It might be, a partnership with a major game like Fortnite. We do those a lot. And then increasingly, we're looking into areas in which we can kind of actually help package games together, where we might be representing a developer and putting them together with a potential distributor for their game. So generally my job is to help advise the agents and then the clients through those agents, in terms of, things to look out for, potential risks, industry standards as we get into, negotiating and trying to improve the overall deal for them. So for purposes of this talk, I thought it would be helpful to walk through some common types of intellectual property, because I think oftentimes people can kind of get confused, or not confused, but mix up different types of protection, and they sort of, use all the terms together, and they'll come to a lawyer and they'll say like, oh, I need a patent. And the lawyer might be like, well, do you, like, is it a patent that you're after here, or do you actually just need, copyright protection for your work? So here are the main types of intellectual property protection. There's more than this. These are the main ones, though, but there's like some like subgenres like trade secret, but I just didn't think it would make sense to go into all that just for the interest of time. These are the main three that you would be dealing with. Copyright is the longest protection in duration. It's the life of the author, generally speaking, life of the author plus 70 years. There's some nuance to that, due to changes in copyright law back in the 70s. If you're curious about, whether something might be about to enter into the public domain, for example, there's tools online where you can throw in, a property and find out if, when that copyright expires. But generally speaking, it's the longest in duration and it's the easiest to obtain. It's a pretty low standard. In order to obtain a copyright into something, it needs to just be a creative expression of some kind fixed in a tangible medium, which means you wrote it down, you have something that you can actually show someone like, okay, this is what I did. Which means that mere ideas, like something that's just like in your brain, that is not going to be protectable without something more substantial associated with it. So yeah, fixed in a tangible medium. And I think the best way to think about what copyright is, it's really like creative. It's art, it's writing, it's basically anything that is coming from your creative mind. Trademark is something that I think sometimes people confuse with copyright, but trademark is really more meant for uses in commerce. So for example, if I am launching a brand or a product and I'm using a logo or a word in association with that brand or product, that is a trademark. And in order to have trademark protection, there is such a thing as common law trademark, but generally speaking, you would have to go to the USPTO and register it, and you actually have to show that you are either actively using it in commerce or you have a legitimate intent to use it. And it's a whole application process. Which, by the way, going quickly back to copyright, you just by way of having created something, you have a copyright into that material. So if I write a book like on a notepad or something, right? My creation of that intellectual property gives me copyright protection even without registering it. However, the reason why you want to register it is because in the event somebody were to take my work and copy it, right, or infringe on it, I can't bring a lawsuit if I wanted to in order to, claim that that had been infringed on without registering it with the Copyright Office, the U.S. Copyright Office. The other benefit is that if you have not registered something, the only damages that you could potentially seek, and when I say damages, it's like the hurt, right? Like the harm that you've suffered. You actually have to show, without a registration, you have to show what your actual harm was. So you actually have to be like, oh, I lost X amount of money because this person infringed on my copyright, which can be difficult to do. Whereas if you've registered it, you have what's called statutory damages. And those are set by law, and you can just point to the number and be like, okay, I'm owed this because I had a registered copyright. So that's another thing to kind of think about, right? Like it benefits you to register in the long term. It just gives you all these additional protections that you may not have just, by your basic common law copyright. And then patent is the most difficult to obtain. It's I believe, the shortest in duration, but it is the most protective. But it's like a whole separate field. Like, I will be honest, I don't know much about patents because you actually have to take a separate exam in order to be a patent lawyer. It's like a whole subset of specialty. Copyright and trademark, you can practice by just going to law school and, gaining experience, but patent's a different story. So we're not really going to touch on that, although I'll mention it briefly at the very end because I'm going to talk a little bit about Pal World, which has been an interesting saga. Okay. So we're going to focus in on copyright because I think that's probably the most relevant for this group, in my opinion. Although, of course, the other protections are important. But I think copyright is probably the most relevant. So what is copyright? I kind of already touched on this, but it protects a form of expression. You write a book, you paint a picture, you create a game, all those things are copyrightable so long as they're fixed in a tangible medium. So when I go to register with the Copyright Office, I actually have to submit my work and be like, this is what it is. It can't just be, again, something that I'm just thinking about. And I'm like, oh, like what if somebody created this thing? And then there's nothing for the Copyright Office to point to and be like, well, did you create it? Like, did you make it? And if I didn't, then I don't really have anything. And copyright ownership affords you certain exclusive rights and protections. So if you're the copyright owner of something, you have the exclusive right to basically control that work with limited exceptions, which I'll get to at the end. In that sense, you have the exclusive right to distribute it, to copy it, to create derivative works, which is an important concept, right? Like, if you have written something and then somebody takes that and then adapts it into a film or some other kind of thing and they didn't get your permission, theoretically they've infringed on your copyright because you are the only person that has the right to do that or to authorize somebody else to do that. And so it definitely, again, having that registered copyright gives you the benefit of also having a record to be like, no, this is mine in the event there's ever any kind of issue. But you do technically have these rights without registration. And so I thought it would also be helpful to talk a little bit about some buzzwords that you might hear just in the normal day-to-day of your work as a game designer or game developer. One of which is a work for hire. So you've probably heard this term, but if you haven't, it's essentially as if the commissioning party, let's say, you are hired to work on a game and they give you an agreement to sign and it says that everything is being done on a work for hire basis. What it means is that it's essentially as if the hiring party, the people that are contracting you to work on this, created it themselves. So all of these rights that you would have as the copyright owner of your contributions, you are essentially saying like, I don't have any of these. It's as if you had created it without me. And generally speaking, you'd be paid, hopefully, in exchange for that. And most contracts will also have a catch-all that'll say, if for some reason this can't be considered a work for hire, then you're assigning all of your rights to your contributions. And this is a really common provision in a lot of different contracts in, the entertainment industry. Like if you are coming in to be part of a TV show, all of your contracts are going to say like everything that you're contributing in connection with this show, right, is on a work for hire basis. So if you're getting a contract to work on something, you want to take a close look at that because if that's not your understanding, right, like if you're collaborating with people and you're actually not sure that it's meant to be a work for hire, like it's something that you want to think about, right? In most cases, if you're being hired to do something, you kind of understand like, all right, like this is what's going on, right? Like I'm gonna be paid for this. I'm not gonna retain any rights to it. But if it's something that you are really passionate about and maybe you're developing on your own or with a friend and you get an agreement and it says, work for hire, just it's just something to be mindful about and to think through. And similar to that, I wanted to briefly touch on a joint authorship. So this concept comes up when you have multiple contributors to a project. It's a work prepared by two or more authors with the intent, and the intent is really important, that the contributions are merged into inseparable parts of a whole. So let's say you are collaborating on a game. One person is handling the key, art and all of that. One person's handling the code. I'm not a game this is probably obvious. Like I took a C++ course in college and I got a C minus, and that's the extent of my technological like prowess. So apologies if I'm using any of the terminology wrong in that front, but yeah. So like let's say like again like you have somebody programming the game and then you have somebody creating the art and then you bring it together. Probably you would be considered joint authors with the other person that's helping you create this. And each author must contribute sufficient amount of original authorship, meaning that that copyright could protect the contribution on its own. So if you separate out, the artwork from the code, you could theoretically copyright each of these elements on their own, but you've brought them together to create a whole. And there's nuances to this because like let's say you are writing a book and you commission or your publisher or whatever commissions somebody to create the cover artwork. That's probably not a joint work because that artwork can exist completely independently from your book. It's just there as like an accompaniment, essentially. That wouldn't really be a joint work, and the authors probably didn't, intend for those two elements to be inseparable necessarily. However, if you collaborate on a graphic novel, that's a different story. That could be considered a joint work. And the reason I'm touching on this so much is because it's important to understand that when you are a joint author with somebody, you have the same rights that they would have, or each author rather would have the same rights that you would have if you just created it on your own. So when we go back to, the certain exclusive rights and protections that copyright ownership has, each joint author has that independently of one another. The only things that they can't do without the other's permission is enter into any kind of exclusive arrangement without approval, because that could preclude the other person from being able to, exploit their copyright ownership over the property. And then you also need to account to that person. So let's say you guys have created something together, and you go out and you strike a non-exclusive agreement for distribution in some way, shape, or form. You have to account to your other joint author in terms of the amount, like the money that you're receiving. You have to be transparent. You have to give them their share. Um, which you might be thinking like, well, I don't always want to have to do that. That sounds like a headache. And everything I just said, is the default. So this is how it works if you don't have a contract to the contrary, which is why it's incredibly important, I think, when you are working on something together and you have collaborators, that you have an agreement that just at the very least outlines the intent, going back to that word, right? The intent of the authors, so that everybody's on the same page in terms of, okay, this person is contributing to the project. We're not going to say it's a work for hire. We're all going to maybe jointly own it 50-50, let's say, if it's two people. However, this party is going to be the one that has the sole right to go out and try and seek a distributor. Or this party has the sole right to go and do XYZ. And then you can talk about, how any profits might be split within the bounds of that agreement. All of this stuff that I just mentioned about joint authorship can be superseded with an agreement to the contrary. This is just the default if there's no contract, essentially. Okay, so we're gonna keep going. So I can pause here, by the way, if there are any questions. I know I'm throwing a lot at you, which is why I said each like thing that I'm talking about could be the subject of its own talk. It's a very comprehensive field. If no questions, I can keep going, but I just figured I'd stop there.
Um, for the work for hire, I have a quick question.
Yeah, please.
Um, what rights are you afforded if you are commissioned as part of a work for hire? Because the work is no longer like I just need a little more on that because if you
Yeah.
do the work, it's then theirs, but there's
Yep.
got to be some rights you have having done the work.
Not necessarily. So, and this is pretty specific to the US. Like there's different concepts, like you might hear like moral rights of authors in other countries. In the United States, it's very much so that if you sign a full work for hire agreement, again, it's as if that person that hired you did it themselves. And so unless there's something in the agreement to the contrary that either, let's say you specifically reserve a right or you don't grant, certain aspects of what you're contributing. And again, this is it depends. It depends on what the agreement actually says. But generally speaking, if you've signed a work for hire agreement for your work, you do not own it. You don't have rights to it, unfortunately.
Okay. Thank
Yeah.
you. And they don't have to credit you like,
Well, credit's a different story because credit is
okay,
something
I wasn't
that,
sure.
again, it's a contractual term. So
Hmm.
they don't have to credit you, but you can negotiate for credit. If you have an agreement that, you're basically agreeing to assign all of your rights away, generally speaking, you can be like, okay, great, like, but I want to be credited as the author. I want to be credited as, a contributor. And that's something that you can talk about in your negotiation with the people that are hiring you to do this. That's pretty common
Okay.
is to have a credit.
Thank you.
Yeah,
Sorry.
of course. No, don't. Did you just apologize? No, this is what this is for.
Also,
Um,
one real quick kind of
yeah,
follow up on that. Understanding that the things that you've said are kind of the I don't want to say bare bones, but that's the basis, right? Work for
yeah,
hire is that none of these things happen. That being said, there are certain things that you should still scan for in contracts, but are kind of accepted within contracts in the US.
yeah. I mean, I think the work for hire language that I typically see is relatively standard. And it'll say essentially that any and all contributions in connection with this project. And when I look at these paragraphs, by the way, I will try to make sure that it's specific, right? So I don't necessarily want there to be the ability to use the contributions maybe outside of the context of the project. That's like a little bit in the weeds though, because I'm representing oftentimes like individual talent and they have a separate set of rights to their specific name and their image and likeness. And that's usually where I'll make those limitations. But in terms of ownership over the materials that are being contributed, most times I'm like, yeah, like I mean, if I'm being hired to go and host a television show, like I'm not going to own any of that. Or if I'm being hired to write something for somebody, if the agreement says that it's a work for hire, I'm probably not going to own that either. There are exceptions, I think, in terms of certain guilds that afford certain rights, like, like if you're a WGA member, it could still be a work for hire, but there's certain protections that that guild affords. But that's like really getting into the weeds. I think just important to know is that this is a relatively accepted concept, but you want to go in eyes open, right? Like you want to understand what it is that you're actually agreeing to. Which, by the way, to back up for a second, I should say, and I meant to say this at the very beginning, that everything that I'm saying today, first of all, it's not legal advice. This is very, very surface level stuff, more like introductory concepts. And I'm nobody's lawyer here, so I can't provide any legal advice. So if you have, specific questions about like your own like basically like instances of working through this, I would encourage you to speak with a lawyer on your own, and work through that with them and have like actual advice being given to you. And then also obviously like nothing that I'm saying here is reflective of William Moore's endeavor. It's just me. It's me giving my thoughts and my general, opinion on stuff. But okay, I think I'll move on unless anybody has any more questions on this stuff. And like I said, this is all like so comprehensive. I could talk all day about this, but we only have an hour. Okay, I'm gonna keep going. Okay, so I was actually asked to talk a little bit about AI, which I think is great because it's such a hot button issue. It's constantly evolving. But luckily, we had very recent guidance from the Copyright Office as of January, which these bullets that you see, I copy and pasted directly from the Copyright Office bullet that went out. And basically, a lot of the questions about copyrightability in AI come from, what is actually protectable in terms of AI contributions that are being used or AI tools. So you'll see here that the Copyright Office has afforded some clarity that the use of AI tools to assist you in your process, it doesn't affect the copyrightability of the output that is being created. So if you're using a tool, um, it doesn't necessarily de facto mean that your work is not copyrightable. But the key concept is there needs to be human creativity in connection with what you're doing. So you can include AI generated material and you're still able to obtain copyright protection, but it's based off that original expression of that work, right? The human element to your work. So the purely AI generated material, that is not going to be copyrightable. So like an example is last time I saw James, we were messing around with ChatGPT and we were creating AI songs with that program, which I forget the name of it now, James. I think it was like Sonos. And I threw a concept into ChatGPT. It created lyrics for me. I then took that lyric and put it into the song generator. It created a song for me. Even though I technically put one and two together, chances are, and it's very case by case still, chances are that's probably not going to be protectable because I didn't actually do anything. Like I didn't write the lyrics. I didn't create the song. I just had an idea of like, what if we did something kind of like this. And then I, put it into this and it sounded like this. Like merely prompting, which they've also clarified, prompts themselves are not protectable. And so I probably could not seek copyright protection for those things. Which means that if somebody were to use it, I would not have a claim to be like, oh, you've infringed on my copyright. And it's interesting because it's a very evolving area, as I said before. And I think as the technology gets better, we're probably going to see continued evolution. Like you'll see on this slide, as of right now, the Copyright Office is saying that we can resolve all this pursuant to current law. But in future, like it might be that we do need a legislative change. As of right now, I think they feel that we can kind of work within the bounds of what we already have. But it's something to consider because, again, it doesn't mean that you can't use AI as a springboard or to create certain materials. You should just go in eyes open in terms of what is ultimately going to be protectable. And then if you're doing something on behalf of a third party, like let's say you're being hired to do something, I would be careful about how much AI you generated content you are utilizing, because oftentimes in agreements where you're being commissioned to work on something, most likely they'll have a representation in there that you're agreeing to, that everything is your original work, that there's no, potential claims associated with it, which is really hard to say affirmatively if you have used AI to generate this output. And then on the right side, you'll see I have this image from this comic called Zarya of the Dawn. And Zarya of the Dawn was an interesting, relatively recent case. I'm just like pulling up the holding here so that I have it for reference. But what essentially happened is that this author had created a graphic novel called Zarya of the Dawn. And the author utilized AI to generate the images. So the image that you see here was generated by AI. And the author had put together the graphic novel and like written the text and published it and sought copyright protection. And eventually and was rejected on the basis that they had used AI to create this. Eventually what was held was that the Copyright Office would grant protection in connection with the text and the arrangement of the images. So the fact that he had taken image A, B, and C and like arranged it in a certain way to tell the story that he was telling, that was protectable, but the underlying images, so this image that you see here, was not, because it was purely AI generated and there was no human contribution to that. Just again, like he had argued, well, I prompted it, I asked for this specific type of image. It doesn't matter. Like that generally is not going to be protectable. So yeah. Oh yes, please go ahead. I see the hand.
Hi, Leah. My
Hi.
name's Connor. I'm in the game design program with CPS. Um, I'm wondering a little bit more about code in that regard.
Mhm.
Um, and the murky thing that like I'm thinking of right now is as like coding, you tend to like reuse your code.
Yeah.
So I'm thinking like if I'm pulling back code from like a previous project, but that project had like used ChatGPT to like help debug or help utilize that code, like what is then like what if you forget like have you created that code before? It just feels like that can be murky waters of like, oh, we used AI for it in the previous one, but we're like, do you have to keep track of that now?
I
Um,
guess it depends. Yeah, I mean, I think generally speaking, like unless you used AI to generate the entire code,
right.
just having AI aspects like to debug, right? I mean, again, like this is very case by case, and this is a very it's a difficult area to say for certain, like, oh yeah, you'd be fine. But I would be surprised if you were denied like copyright protection just for having used AI in order to debug. If you wrote the majority of it or even, most of it, right, on your own. So I would be less concerned about that, honestly, because I think everybody recognizes at this point that AI is a tool that can be used in order to, make things easier and to create things. And I don't necessarily feel that that would interfere with the artistic expression of the game, which is really the main. I mean, the code is copyrightable as well, but like when you go to copyright a game, you're copywriting the entire package of, the artwork, like the graphics, all that, alongside, the code itself.
Mhm.
So yeah, I think difficult to say for sure without like seeing it and kind of working through the analysis, but based off what you told me, like you're probably okay. Um, but you could always, like the Copyright Office is really actually quite useful. They've got a lot of resources. They've got YouTube videos. Like it's always something that you could like throw out and ask. Like you could try to seek protection and registration and then like disclaim, if they I haven't done a registration in a long time, actually, to be completely honest. It's been a while, but I believe that there is an ability to kind of disclaim certain materials that are, maybe in the public domain or maybe perhaps AI generated. But yeah, I think based off this current guidance, you're likely okay. But just be mindful of it, I guess.
Would you recommend potentially like starting to like with ChatGPT as
Mhm.
an example, you can save your like queries. Would you recommend potentially like starting a habit of like if you're working on a project to like save that, just at least like if there's ever any questions? It's
Yeah, I don't think that's a bad idea. Just to kind of have a record of what you've contributed via AI, right? Just so that you yourself understand. Sorry if you're seeing those pop-ups. I don't know how to like get rid of those. Okay. Yeah, no, I think that's a good idea. Just so that you have like a record. But again, I think what you just described seems relatively low risk.
awesome. Thank you, Leah.
Yeah, of course. Okay, so then we're gonna move on. Let me see, how am I doing on time? Okay, pretty good.
Also, one real quick thing is
Yes.
whenever you mention something that I think needs a follow-up, I kind of put it in chat. So, for instance, when you mentioned the AI music thing, I dropped Suno in there, or when you said
Oh, great.
WGA, I said Writers Guild of America, just to make sure you
Yeah.
know that like these things are being followed up on.
Okay, cool. Thank you. Sorry. I appreciate that. Okay, I don't know why I called this slide Uh-oh Pal World, but I thought it was funny at 11 p.m. I just thought it'd be interesting to talk about, and I'm doing a bit of a pivot here, to talk about a real world example of an ongoing case, not to do with AI, but to do with potential infringement. So presumably you guys have all heard of this game, and presumably you've heard that Nintendo, at least in Japan, has filed a lawsuit against the developers of this. And I think in the legal community, there was like a bit of a surprise because we all sort of assumed that if Nintendo were to take action, that they would do that on the basis of copyright infringement because the designs of the Pal World characters looked similar enough to Pokemon that, if there were to be a case, I think we all assumed like, oh, it would be based off that. But instead, what they went with was that they're actually suing for patent infringement, which generally is like a much better, if you have like a registered patent and you can show that somebody copied it and infringed on it, like that's a pretty good case. Whereas copyright, I presumably, I don't know this for certain, but presumably Nintendo felt like maybe there was enough of an argument that the designs were not copied, that if they lost, it would be a PR nightmare. I mean, I don't know for certain, but an interesting development as of a couple weeks ago is that Nintendo obtained a very similar patent in the US, because this lawsuit that's ongoing right now is in Japan and is based off a Japanese patent, which I know nothing about. And now they have this US patent, so it could open the door potentially for a similar action in the US. And interestingly, the patent was for like a mechanic to like throw an object and catch, for lack of a better word, a Pokemon, right? Which they're claiming that Pal World has infringed on. So it'll be a really interesting thing to follow. I'm wondering if now there will be action in the US, which will be a little easier for us US lawyers to follow and understand because we'll have access to the complaint. We'll be able to see what Nintendo is alleging. But as of right now, that has not happened. So it's just something to keep an eye on. And I thought it'd be interesting to bring up because it's relevant to your space. But yeah, it's an interesting case. And then I know I'm running a little over in terms of the Q&A, but I do want to briefly touch on fair use because this is another buzzword that I feel it gets thrown out a lot. And when I hear people talk about fair use, it's usually in the context of like, oh, this is fine. It's fair use, whatever. And I want to really emphasize that fair use is great, but it is a defense, which means that you are already kind of in hot water with somebody when you're raising fair use. You can't, somebody is not going to be precluded from bringing a claim against you because you've disclaimed on YouTube that it's fair use. They can still bring the claim if they feel that you've infringed on their rights. And then the burden is on you to be like, okay, well, actually, it's fair use, and I'm going to show you why. And when a court looks at something as to like in terms of whether it's fair use, it's again a case by case analysis, and they look at a bunch of different factors, namely like what was the nature and the purpose of that use? Is it quote unquote transformative? So if you're taking somebody else's work and you're using it in connection with your project, are you commenting on that project in some way? Or like, is it a parody? Is it educational? Like they think about how and why you used it, how much of it you used. Also, is there an impact on the general market? Like by you using that, have you precluded them from potentially making money, or doing a similar thing themselves? And those are all factors that are taken into account when analyzing whether or not something was truly fair use. So again, like it's something that it's useful, right? Like, and I think a lot of industries rely on this to a degree, and they also do a risk analysis, right? They're like, okay, like, is this actually going to be an issue? Like, is anybody going to really find out? But it's just important to be aware that it's a defense, which means that you are already being dinged for something. And I have this picture of Prince next to this paragraph about fair use because very recently there's a case that we refer to as Warhol that actually surprised a lot of people because these images that you see, it was a original photograph taken by a woman whose name escapes me right now, and then Andy Warhol created this painting based off that original photograph, and had this sort of artistic expression associated with that. And then I believe Vanity Fair or another magazine wanted to commission like additional prints of this Prince photo, and create like a display, like I think on the anniversary of his death or maybe in commemoration of his death. And there was a lawsuit, and the court actually found that this was not fair use, that they needed to have gotten the permission of the original photographer in order to create this artwork, which was really surprising to a lot of people because I think a lot of people would look at this, at least in the legal community, and be like, oh yeah, like, you've transformed it, you've commented on it in some way. And this is a really recent case, and I think a lot of people, there's different opinions in terms of how much this is actually going to impact things, but it's something to be aware of because currently the landscape is that the courts are taking a bit of a stricter approach in terms of, weighing on the side of this was actually not fair use. You should have gotten permission to use this. So definitely recommended reading if you're ever curious. We'll see how far it goes. Like a lot of people, some people are like, oh, this is establishing new precedent. Other lawyers are like, I don't, we'll see if this is actually going to impact things because it is so fact specific, right? So yeah, it's just something to kind of keep an eye out for. And that's everything I had for this. I know I kind of went over, like I said, the time that we allotted for Q&A. I have some links here. Just there's a really good video on the Copyright Office's YouTube page about joint authorship that really breaks it down. They actually use the same example that I threw out here about like the artwork for a novel versus like a graphic novel to demonstrate the difference. And then also just a link to the Copyright Office's guidance on AI generally, which again, very emerging issue, very emerging space. But it's exciting. It's a cool tool to use. And I think, as the technology evolves, like I said earlier, it'll continue to be interesting how US copyright law reacts to it. And that's it. That's all I had. So yeah, happy to open it up to questions. I think looks like we've got about 15 minutes left. So um, I'm
Yeah.
all ears.
Thank you so much. And yeah, it's okay that you ran over because now we know everything about law and we'll be
Yeah, you've
protected
learned
forever.
everything. Yeah,
So
exactly. Yes,
it
precisely.
all worked out.
Yeah. I think
Um,
maybe some parting words before we really get into any kind of Q&A. My general advice is, if you have a contract that you're presented with, I know it can be expensive to hire a lawyer, and I fully get that. And I'm certainly not going to sit here and be like, you have to pay thousands of dollars to get a lawyer to read every single thing that you've ever signed in your life. But even just maybe like investing in like an hour with an entertainment lawyer, someone who really knows their stuff, and getting like a primer beyond what I can really touch on today in terms of like if it's an important deal to you, right? Like you want to make sure that you're understanding what you're actually signing. I think it's worth it, just to have somebody who is able to really explain what certain things mean. And it doesn't necessarily even mean, depending on your leverage, you might not be able to negotiate it much, but at least you'll know. And you'll know what it says, and a lawyer can kind of walk you through like, oh, like I think you should, if you were able to push back on these certain things, and if you wanted to, again, if it's a big enough deal, if it financially makes sense for you to bring on a lawyer to actually negotiate it for you, there's things that they can weigh in on that you might not be thinking about. So definitely encourage that. And then yeah, for the reading, I think again, Copyright Office is really informative in terms of how they're looking at things. And you don't actually have to be a lawyer to register a copyright or a trademark. You can just do it as anybody. So that's another thing too. Like you don't actually have to hire anybody to do that. You could, like there are lawyers that do that. I used to do it at my old law firm. But it's not a requirement for you to be an attorney to register. So that's another important thing to know.
yeah, one thing I will add on just from
Yeah.
the developer creative side of this, and of course not advice, just kind of like lived things from my experience
Yeah.
too, is that a lot of it when you think, for instance, like, oh yeah, like I don't have the money to put towards like a lawyer for all these things, a lot of it's going to come down to how deeply you thought about the game that you're working on and how much worth you want to put into the idea and the end product. If you think it's going to be a really great big success, it probably would make more sense to put a little bit of money up front now to make sure it's protected and everything's
Yeah.
fine. And if it's a throwaway idea and you really don't care, it may not make as much sense.
Yeah.
Um,
I completely agree with that. I completely agree with that. Sorry, James, I didn't mean to cut you off.
Oh no, you're totally good. The other one I was going to say too is a lot of people are really freaked out about contracts, and I especially was too. But something to also keep in mind is that contracts in terms of teams, I have also found to be really good first kind of tests of team strengths. It shows if you are on the same page for where you want to see the project go, and it also shows how you each see your own role in the project.
Yeah.
While handling contracts, as painful or as uncomfortable it might be, it'll really let you know if somebody's like, oh, like you thought I was only doing 25% of the work. Like I thought I was doing 50.
Yeah.
And that's really good to get out of the way early on because those things, for lack of a better word, they can kind of fester or they will grow in bad ways if you don't tackle them first. And when
Oh
you
yeah.
do tackle them first, they go really well because everything's very clearly defined. And if you want to open up a contract and everyone's open to it, you can always renegotiate later.
Yeah, I think that's all incredibly true and really smart to point out. I will say in my legal career, some of the messiest business divorces I have experienced were amongst best friends, or I guess at that point, former best friends, which I don't say to scare anybody. And you don't have to be like overly litigious in the upfront. It could really just be a pretty simple document, right, to outline the understanding that everybody has in terms of the project. But it's a really good thing to do up front because then you just don't have to worry about it anymore. And as James put, like you could reopen it later on. Like if everybody agrees, you can always amend an agreement. Everybody has to be on the same page, but that happens all the time. You'll be like, oh, the circumstances have changed, or like, okay, now we need to, like, let's say you need to consolidate all of the rights into, like, you set up an LLC in order to produce something, or to assign the rights to a third party, whatever. And in order to do that, you need to have everybody kind of contribute to that LLC. Like you can work through that. And I think it's a good thing to do up front when everybody is excited. And I know sometimes people can be like, oh, well, these are my friends, like I trust them, which is great. Like, I think it's great. But at the end of the day, like you just want to have the conversation, right? At a minimum. Because you could be in a scenario further down the road where everybody is not happy. Yes, I see the hand.
Awesome. I had a question that came
Yeah.
up earlier, and this might be helpful with like going back to copyright. Do any publishing development platforms that you're aware of have built-in copyright registration? I'm thinking of like some platforms like YouTube or Canva that like mention some things about copyright. Um, I'm just wondering if there's like any platforms you're aware of. Like we all use GitHub, but I wonder if it's public, that's considered like public domain. Um, if you're willing to speak on maybe like a couple platforms you're familiar with, that'd be great.
Yeah, I mean, I think let's take YouTube because I think that's the easiest thing to talk about. So is the question, by way of publishing on YouTube, whether or not you've then obtained copyright protection, or is the question, does YouTube somehow own that? I just want to make sure I'm answering correctly.
Oh, yeah, great clarification. More of like if we publish it to YouTube, do then we automatically have like copyright for that because it
Got
was.
it. Okay, so in a way, yes, because what I mentioned earlier was that you have common law copyright protection, because you've created something. So it's not really necessarily the act of putting it on YouTube that creates that. It's at the inception of when you've created it itself. So once you put pen to paper, for lack of a better phrase, you have copyright protection. But uploading something to YouTube or onto another third-party platform does not give you copyright, like a registration. You have to do that with the Copyright Office. And it's an application. It's pretty quick. I think you pay like $50, something like that. And then you get a registration official with the Copyright Office. But no, YouTube will not do that for you. In fact, those platforms generally disclaim any like liability in connection with copyright. Like if you have something on YouTube that is infringing on somebody's third parties, like their rights, they can issue a takedown like under the Digital Millennium Copyright Act. I
Mhm.
think I got that acronym right. I always just call it DMCA, but yeah, generally like their terms and conditions are going to say like we're not getting involved. Like we are just the method by which you are putting this out into the world. We have nothing to do with, who owns what.
Awesome. Yeah, I think that's a great summary. So regardless of like common law relevant to any platform, it would, if we wanted to be copywritten, like registered, we'd want to go through the office.
Yeah, you have to in order to register it. And I think it's a good idea to register because, like I said, if somebody ever infringed on your rights to that property, you can't do anything about it unless you have a registration. And doing that preemptively, is what can help you have more in your toolbox in terms of the damages that you might be able to get. So it's just smart. It's like a quick thing to do. You could, like I said, you don't have to be a lawyer to do it. You just fill out a form basically, and you pay the money.
Awesome. Thank you.
Yeah, of course. I see another hand with Zanon.
Yes, yes.
Hi.
Thank you very much. It was very informative,
Good.
Leah.
Glad.
I had a question regarding mods, like game
Okay.
mods.
Hmm.
And I know earlier you talked about derivative work, fair use of existing work, and that seems to be irrelevant. I wonder if you have any insights in terms of like how that like happens with like entertainment, especially games in particular, like how I guess the like companies perceive that and like how that works in general because I feel like mods bring a lot of positive, but I also feel like it's always been in a gray area. So I wonder if they have anything to say about
Yeah, no, that's a really good question. And I think it is a bit of a gray area. And I also think there's a difference between like user generated content versus like actually modding a game. It depends on sort of what you're doing with the mod, I would say. Like some developers, I think, kind of welcome that. Like I know Baldur's Gate just put out like in one of their recent updates, like an ability for you to actually like actively download mods into your game. I play on PS5, so I don't know how the PC part works, but like those are like authorized and people are like they're happy with it. In other circumstances, more litigious companies might not be happy with it. But again, like if you're just kind of modding for your own use, like they're not going to be able to really tell, right? You're just kind of like using that for yourself and you're just playing and you might be like not charging for it. You might just put it out into the world and chances are you're probably not going to get in trouble. But if you are going out and let's say you've released like a modified version of, we'll take Pokemon again, and you're charging for it and you're like, oh, this version of Pokemon, I've added guns. I don't know. I'm just using that. Like Pokemon with guns. Um, Nintendo might be like, okay, we actually don't love this because you are tarnishing the Pokemon brand. It's like a lovable brand and you're making it cruel. And we don't like that, so we're gonna pursue something. So again, this is the famous lawyer phrase, which is it depends, but it does depend. It really depends on the circumstances and what you're doing. But yeah, I mean, I think the fair use analysis could apply. You just really got to kind of talk through again the different scenarios.
Okay,
Does
and
that help?
based on yes, and based on what you said, it seems like a lot of it comes to like whether you're doing it for profit or not, right? It sounds like that makes a big difference.
I think it can make a difference. It's not the only element. But yeah, like if it's being used commercially, that's an element that people take into consideration. If it's something that you're just kind of like doing on your own for fun, again, it depends. It depends on who the company is. If they don't like it for whatever reason, they could still be like, hey, like you actually can't do this. Which by the way, like most companies, unless you've really done something bad, the first step is probably just going to be a cease and desist. They're probably just going to be like, hey, please stop. And if you stop, then you're fine. But where people get into like protracted lawsuits is when they're like, actually, I don't want to stop and I don't have to, and here's why. So, I usually the first step is not to like sue somebody for millions of dollars. They'll usually just be like, hey, cut it out.
Okay, sounds good. Thank you.
Yeah, of course. I see another hand, Ara.
Yes. I also want to say thank you firstly for that really digestible presentation. I appreciate it.
Oh, good. I'm glad.
Yeah.
Of course.
And actually, Xenon was talking about a mod, and that also reminded me. I used to work at a research lab, and we used mods for our research. And so, I wanted to ask if you knew anything about whether fair use tends to be a little bit, and I put in quotations, more lenient or less strict if they're used for research purposes.
Mm-hmm.
And if you have any interesting cases about like uses for research where it was kind of not like surprising to you, for example. I would love to hear cases like that too.
Yeah, I don't know of any off the top of my head. I'd have to look into it. I don't know of any cases specific to like mods being used for research, but I will say generally like, educational purposes tends towards the fair use end of the analysis, which again, just to emphasize, like this is something that like a judge is going to go through like all these elements and like it's so fact specific, right? So I can say kind of as a blanket, like, oh yeah, like educational purposes are generally fine, but then if there's something that I'm not, thinking about in the moment, like because I don't have like the full details, like it could turn out differently. And I think in this post-Warhol landscape, things that people tended to think were fair use may not be, just depending again on like how the court is interpreting it. But yeah, I mean, generally speaking, like it's relatively known that if you're just using something for educational, internal purposes, you're not commercializing it, you're not doing anything that's going to get in the way of the enjoyment of the original author's copyright, which is really the key here. Because again, if you're the copyright owner to something, you technically have the exclusive right to do things with it. You have the exclusive right to distribute it. You have the exclusive right to create derivative works from it, all of that. But what you're describing sounds like you're commenting on it, you're trying to understand something about it. I would think that would tend more towards fair use. But again, like it's so case by case, and I certainly would never want to tell you like, oh yeah, you're fine, and then there be a problem. So I think if you are ever in a scenario, like there are lawyers, by the way, that do like fair use analysis as their full-time job. And so you could always consult one of those people and be like, hey, I have this project. I have not gotten permission to use this element because I need it in order to make my point with this research. Like, do you think that's okay? And then they can talk you through it.
Yeah, that makes sense. Generally, the trend was a little bit leaning toward fair use, but of course, it's a very case by case with
Very
everything.
case by case. But yeah, generally speaking, like I think, like I'll like for example, these images that I included in this presentation, I did not go out and get a license for the Prince photo. I just threw it in here. But like this isn't going anywhere, like this is maybe going to be on YouTube. I'll let you know if I get dinged for it, but probably not, like I think this is like an educational presentation. I could not have made my point about the Prince photo without showing you the photo and showing you the artwork. And so that would probably tend towards fair use, just to use like a literal real-time example.
All right, awesome. Thank you.
Yeah. I see Genevieve has a question.
Yeah, I guess I was just sort of wondering when you would recommend like putting in a copyright or like you know what I mean, like making your work legally. Because you said like if you have registered copyright, you have more protections.
Yeah,
What point makes sense to get that?
that's a
In your,
really good question. Yeah, sorry, I didn't mean to cut you off.
oh no,
Okay, sorry. Yeah, I mean, it depends on the type of project. I think if you can swing doing it kind of in stages, so like I'm gonna use, this isn't really gonna be applicable to games, but this is an easy way to explain it. If you are writing a screenplay, and let's say you just have like a treatment and an outline, I think it's worth submitting that. I think then, once you've actually written the screenplay itself, I would recommend submitting that. And I do believe, and I haven't confirmed this lately, but I do believe there's a way to update, and kind of, as things change to like update the protection, and update the property that you are copywriting. But at a minimum, like once you have like a final product, I would, and before you're really making it public, I would register it. So if you're creating a game, you could theoretically register certain elements separately, but you probably want to just be like, okay, the game's done, it's created. I've got all the elements kind of packaged together. At this point, I'm going to protect it. But I do want to emphasize that that is as it relates to registering. But the moment that you put pen to paper or fingers to typewriter, you know what I mean, keyboard, you have rights to that property. You've created copyright by fixing it in the tangible medium. That's the main driving force behind when you have protection. It's just you have better protection if you register with the Copyright Office.
okay, thank
I don't
you.
know if James, I don't know if you're still there, but if you want to link maybe the Copyright Office website, because that's how you do it. You just
Oh
like
yeah,
go
of
on.
course.
Yeah. And you know what? I don't want to speak out of turn because I don't recall exactly how it works when you're like updating the property, but like I do see people like copywriting like drafts of things. I think a thing to also keep in mind though is like once you put it up on the Copyright Office, it's public record at that point. And people can go and look at it. So if you are like maybe not ready to show it to the world yet and it's still kind of ruminating, like as long as you're not like the risk of somebody infringing on your work at that early stage is probably less than like once you've actually put it out into the ether. So it would make sense like maybe prior to publication is a good time to do it. But if you're worried, it doesn't hurt if you have the money to spend to do multiple registrations. But let me just think. Yeah, I think that's basically it. But yeah, James can send you the link just so that you can. And like I said, there's a lot of resources on the Copyright Office if you have like further questions and if you're not sure something is exactly protectable or if you're not sure how to register it. Those are things that I think the Copyright Office resources can help clarify. And then also if you did want to talk to a lawyer about like, how to if it's a complicated project and you want to register it, and you just need guidance, like there are lawyers that can walk you through that too.
Yeah, thank you.
Yeah. Um, but yeah, I think we're out of time. We actually went a little over. So does anybody have any final parting thoughts, anything like that? Hopefully this was helpful. I know again, it's a really comprehensive area. Definitely encourage everybody if you're interested to like do some follow-up reading on some of these topics. And if there's anything that you were like, wait, this didn't really make sense to me, or like, oh, I had like an additional question. Like I can't again like provide legal advice, but my email's up here. Feel free to reach out anytime. Happy to chat or have like a one-on-one. Again, can't give you anything really concrete that you can take in action, but like I'm happy to chat. Yeah, I think that's it. James, anything? Parting words?
Yeah.
I
Thank
got
you
to
to
point to
everyone.
everybody first before we
Oh
go.
yeah, sorry. Yeah. Thank you and thank
Yeah,
you and
yeah.
thank you and thank you and thank you. And I missed one. Thank you. Thank you all
Thank
for
you.
coming today. Yeah, and thank you, Leah, too. This was yeah, really informative, and I echo what
Good,
everyone else said. Incredibly um parsable, very understandable.
good.
And
I'm
even
glad.
though I know you were saying at points like, "Oh, this may not pertain to games," like all of it did, all of it registered and hit, I think, really important notes. Like it covers all these aspects. Like even at the beginning when you're talking about all the different parts of like law, I think I put something in the chat saying like all of these facets affect video game making, like music
Yeah.
and art
Hmm.
and code. It all comes together for games, which
Yeah.
is fun, but also makes it a little more complex.
Yeah.
So yeah, this was really great.
No, I'm glad.
And
I'm actually like I'm kind of curious for myself also like because I it's been a while since I've really thought about, in terms of like timing of registration. That was such a good question. Like I actually want to look into that a little bit, like in terms of
Mhm,
like when is the best time to register? Because when I used to do it at my law firm, I would usually be asked to do it like when somebody had like essentially a final product.
mhm.
So I don't want to tell you anything wrong about like being able to update that registration. I believe that to be the case, but this is specific to Genevieve who asked the question. So yeah, I kind of want to like double check that. So maybe I'll do that and I'll like tell James what the answer is,
Yeah,
and then
that'd be awesome. My bets on it, and this is just because at some point I looked into it, is it looks like you can pre-register things or you can pre-copyright them, but I don't know what that comes with. Like, I don't know if that means you have to deliver by like the expected date, or if you can do that and then it just sits there and it doesn't do anything, or what that
yeah,
actually legally covers.
I think like doing it alongside when you are planning to publish it is a good rule.
Mhm.
I think that's the most logical time because then you've got again like more or less the final product. And you're not completely out of luck, without yeah, go ahead. Sorry. We're talking about the thing that you asked about, so you can just jump in.
Yeah.
Yes,
Yeah.
I was actually curious as you're talking about this, if you're thinking about when you publish it, how does copyright and giving it to playtesters work? Because then if you're giving it early to people who are playtesting, they have the copy. And I know a lot of companies that give you playtests also give you NDAs,
I was
which
just gonna say, like an NDA is
fun legal
probably,
things. But
yeah.
if you're an indie developer, I don't know how, like, then you have to like craft an NDA and give people an NDA, and then you have like, can the copyright office help me with that? Like,
The Copyright Office won't be able to help with an NDA, and I hate to encourage this, like it's a pretty, you could probably find a form on the internet and tailor it to your needs.
yeah.
And I know they're kind of scary, and you don't have to do like a huge like, oh my God, like you can't talk about this ever, or else like I get $1 million if you do. Like it's more like an understanding
Hmm.
of like, hey, like this is private, like I'm just giving this to you in confidence, like, and I'd just like to make sure I'm protected. So here's like a very brief NDA that you're not going to disclose the game before I'm ready to release it. And that's really it. Like I think that's the best way to do it. And I think if you're at like the play testing phase, it might be a good time to register. I'm actually wondering what the Copyright Office says about this. Because like I said, again, you have protection at common law the moment that you create it.
Hmm.
Um, I see, wait, I just saw like a expectation that your work will be completed within 5 years of. Okay, cool. Yeah,
Yeah,
so that's actually
perfect.
something I didn't really know about. I've never had to pre-register something, but that's an interesting. I don't know if people utilize that a lot, I will say, because it's not. I don't really know what it gets you. Maybe it gets you some protection. I'd have to look into that a little bit, but yeah, I don't exactly know what the
It's
benefit of
like a
doing that
warning
would be.
shot.
Yeah, well, there is such a thing in trademark as an intent to use, which is where you say, like, I don't want anybody to like come in ahead of me. I'm developing a brand. I have a demonstrable intent to use this trademark. And so I'm essentially pre-registering it. But yeah, I don't know. I'll look into that a little bit. I can send some follow-up stuff to James that he could circulate.
Yeah, for sure.
Yeah, but like that's not something that would come up in my day-to-day pre-registering. Like it's not, I don't think that's like a common way to protect, but maybe.
One thing I will throw on real fast,
Yeah.
just from the user side, not the legal side, is I have some friends who actually ran into a NDA breach thing. I want to say maybe like a
Uh-oh.
year ago.
Yikes.
Well, it was because they had some playtesters, right? And they sent all the playtesters the NDAs, and the playtesters were playtesting the game, and one of them ended up leaking like footage of the game, right? And that was a big no-no because this was like an expansion, and it's like people wanted to not be spoiled. So the way they handled that is they were not able to get monetary compensation out of this person, but the two things they did that were smart was number one, the NDAs were pretty ironclad in terms of you're not going to share any of this.
Hmm.
So they already had that. And then the second one is that they had effectively like I'm going to use the wrong terminology too, but like tracers in each of the builds. So if somebody
Mm,
was playing the game, they would be able to look at the footage and they would basically be able to see like a ghost number somewhere on the screen that would tell them which copy of the game was being used improperly in this way. So because they were able to figure out who did it and because they had this ironclad NDA, they were basically able to send their lawyer after this person and basically tell them like, "Hey, you better knock this off. You better delete all this stuff or we're going to come after you for like loss of revenue as outlined in this thing because you're going to prevent people from experiencing
mm,
the game because you've already leaked it." Um, and it didn't, of course, prevent the damage that was kind of already done. And one of the big things you have to consider, at least they had to, is like, what are you going to get out of this? Will it be worthwhile taking this person to court? Like, will the money be spent following this up going to, like, is it going to result in things you want? So ultimately, the person took their stuff down, and then that person just became a warning to all of the other playtesters to
yeah.
don't screw with us because we're serious. So that in of itself was good because it just kind of reinforced that cycle of like, you've lost all your privileges, you're effectively on a blacklist for all these companies we know. Like, that's kind of the outcome for that.
Yeah.
So not ideal,
Not
but the
ideal.
point is that when you set it up appropriately, you can get outcomes that effectively help yourself and help everyone else
Yeah.
that like about, hey, don't rely on this person.
I think the final word I'll say on like when to register is that if it's something that is separately copyrightable, so like in that treatment and draft example that I provided, those are technically separate elements of the project, right? Like it's kind of in different stages. But I would say like in terms of like a game, I would I mean, again, this is maybe something to look into a little bit, but I would think that it would make the most sense to register it like when it's ready for release. And you could technically register it after release. Like what was put in the chat, like, you have this like 5-year window to do it, but probably better to do it preemptively. But yeah, I would say like as close to final as possible. Because like I mean, like if you have like a quick change in the code, right? Like if you debug something, I don't think that's gonna like invalidate, like they're not gonna be like, oh, this is a different work, like I think you'd have an argument that you still have that registration and you're protected. But if there's major changes to the project, that's kind of why you might want to wait until a little later once it's more final. But yeah, we're a bit over, so I do have to jump, unfortunately. But I hope everybody enjoyed the talk. I know it was a lot of information. But hopefully everybody has a good day.